regulating synthetically generated information online, decrypting the IT Amendment Rules 2026. I am Zikra, and it is truly my privilege to anchor this session. Today's lecture is a part of our Cyber Sunday series, an ongoing initiative dedicated to building awareness, deepening understanding, and encouraging meaningful engagement across the fields of cyber safety, law, and technology. Each session brings together experts and practitioners who offer real world perspectives on cyber threats, digital governance, and investigation strategies. This is our 16th Cyber Sunday, and with every session, we grow not just in knowledge but in our ability to speak with clarity, confidence, and purpose, and to carry that awareness back into our communities. If you are ready to dive in, type ready in the chat box and send us a thumbs up. It's a genuine honor to introduce our guest speaker for this evening, Mr. Shikhar Gupta. Mr. Gupta serves as an assistant professor in the Department of Law, Forensic Justice, and Policy Studies at the National Forensic Science University, Gandhinagar, and is currently pursuing his PhD from Faculty of Law, University of Delhi, with a focus on law and artificial intelligence. He is an alumnus of University of Allahabad and holds his LLM from Gujarat National Law University. His areas of expertise span information technology, electronic evidence, AI, and emerging technologies and their intersection with the legal system, a combination that is increasingly vital in today's digital world. Mr. Gupta has presented research at numerous national and international conferences and has been invited as a resource person and panelist at seminars and workshops across the country. He has trained judicial officers, senior police officers, defense personnel, and forensic experts on topics ranging from Information Technology Act and electronic evidence to data privacy framework and online consumer protection. He has delivered these programs at premier institutions including LNJN, NICFS, and the Indian Institute of Public Administration. With his extensive experience at the interface of law and technology, Mr. Gupta is a passionate advocate for the ethical integration of technologies like AI into Indian society and the legal system, always with an eye towards a safer and a more secure digital future. Sir, we are truly honored and delighted to have you with us today. A warm welcome to you. Now, without any further ado, I would like to hand over this mic to you, sir. Thank you so much.
Thank you, ma'am. Thank you for the thorough introduction that you have given. So I would try to do justice to this session within the time span that has been given to me. I would directly start with the presentation. Good evening to all the audience members present here, which I believe law students as well as professionals from the legal community, including professors as well as lawyers. So I hope my session today would be fruitful for you, both for your legal research, for your profession, as well as for the awareness of our cyber rights in the cyberspace. So without taking further time, I would directly start with my presentation. I hope the screen is visible to all of you. Okay. So the session topic today is regulating synthetically generated information, where we are going to deal throughout the session with the IT Amendment Rules 2026, the amendments that have been made into the Intermediary Guideline and Digital Media Ethics Code of 2021. So before going into the details of the rules and the regulations, let us discuss first why are we having this present session. The prime reason of having this present session today is the deepfake crisis that has emerged in the cyberspace. Today, seeing is no longer believing. We cannot trust our sense organs, our ears, and as well as our eyes to believe the content that has been presented before us. Our sense organs cannot distinguish the truth or the untruth of the content that is being presented to us. Earlier, we used to see a video, a recorded video. We would be sure that this incident has happened. But today, even our eyes and ears can deceive us. Such is the nature of deep fakes that are being circulated in the cyberspace. So therefore, the present session becomes much exigent in the today's cyberspace. I would also take a moment to underscore the gravity of the present session and the requirement of the regulations for deepfakes by drawing your attention to certain incidents that happened recently in the recent years. So we all are aware of the insanely viral video of Rashmika Mandana in the elevator, which was later on found to be deepfake. The incident did not occur in isolation. It happened in quick succession, following similar high-profile deepfakes targeting various actresses like Katrina Kaif, Alia Bhatt, and Kajol. For example, a highly realistic video was circulated on social media platforms showing an individual whose face was replaced with Bollywood actress Alia Bhatt using sophisticated deepfake technology and was shown wearing a floral sleeveless top, sitting on a bed and making gestures that were deemed as inappropriate. While in another video, a mock video made using artificial intelligence, Kajol was seen as changing clothes in front of the camera. Now, these videos sparked massive debate as well as outrage throughout the nation regarding the non-consensual nature of the digital manipulation and identity theft. These videos also highlighted the fact that highly protected celebrities can be easily targeted and violated digitally. Then the ordinary citizens are incredibly vulnerable if such high profile celebrities can be easily targeted in the cyberspace. Second incident that I want to bring your attention here is a video of PM Modi playing Garba that was circulated before 2024 elections. So during the Dashera festival, a video went viral online showing our Prime Minister Narendra Modi ji dancing on Garba. Now, interestingly, it was later on found out that the video was specifically of a doppelganger of our Prime Minister, a person who was the look-alike of Prime Minister, and not purely an AI-generated deepfake video. However, it was still suggested by certain experts that the reality was augmented using artificial intelligence technology. The video was so convincing that the Prime Minister himself brought up the video in a press conference at the BJP headquarters and to address a massive red flag about the dangers of deepfake and how easy it is to mislead the masses. He officially urged the technology platforms as well as the media to educate the public to curb the spread of synthetic media, noting specifically that in a democracy, AI-generated misinformation could be used to manipulate voter sentiments and cause social unrest. These two examples are from the celebrities or the political, about the political leaders. But there is another kind of deepfake incidents that have been emerging that are related to deepfake audio cloning or deepfake audio visual cloning resulting in monetary frauds. So in these videos have been emerging since 2024. I have taken certain examples, but if you will search deep, the internet is full of such examples. Even every day, I have personally received such deepfake video call, and many of the persons that I know, many of the colleagues that are working in the government departments have also, I know, that have received such AI generated calls. So what happened? Just I'm quoting two incidents. In Hyderabad, a 59-year-old woman was defrauded of rupees 1.4 lakhs. What scammers did, they used AI voice cloning to perfectly mimic the voice, the tone, and the specific Punjabi dialect of her nephew who lived in Canada. The cloned voice called late in the night, claiming that he was in an accident and was facing jail time and therefore urging the woman to transfer certain amount of money discreetly to, which she actually did in this case, and therefore defrauded. Now, one high-profile case that I want to mention regarding the cloning of Bharti's chairman Sunil Bharti Mittal itself. So we all know the Bharti Corporation, the Bharti Airtel. Fraudsters successfully cloned the voice of Sunil Bharti Mittal, the chairman of Bharti Enterprises, to call a senior executive in Dubai, instructing a massive fund transfer. However, the executive in Dubai realized in time that it was perhaps a scam, because Sunil Bharti Mittal would not instruct for such massive fund transfers the way the call was asking to do. But it did prove that even the elite corporate voices can be easily weaponized in this age of deep. So I would also like to point out another major issue, a challenge that is emerging in the cyberspace, a new kind of fraud that is emerging in the cyberspace, where SGI, the synthetically generated information, is being escalated towards a much darker trend known as digital arrests. So I'm sure most of you here would already have heard of the term digital arrest. How it is related to SGI? In many of these digital arrest cases, criminals use synthetic visual and audio elements to impersonate actual CBI investigating agencies of the government, like CBI or the police, and digitally trapping their victims in their own homes for days, or sometimes some hours, or sometimes even days, and often extracting lakhs and crores from them under the guise of SGI created fake legal warrants or fake digital IDs, which appear to be true. So these kind of incidents underscore the fact that deepfake has become a reality, and it is not just being used for targeted parodies, but it is actually being used in complex financial frauds, complex crimes related to the violation of bodily integrity of the persons, for showing persons in obscene or pornographic conduct like that, or sometimes even defamation and the offending the dignity of the individuals. So in this scenario, before coming to the regulations, I will also want to point it out the nature of the threat that we are facing with the emergence of deepfake technologies. Democratization of deception. Now, I want to talk about democratization of deception, which has resulted in because of the extensive use of the AI-generated technologies. AI tools today have made the creation of hyper-realistic visual and audio fakes so easy. That was once the domain of the Hollywood or sometimes the Bollywood. Even the Bollywood was not so capable of producing such real content that was CGI, or we can say SGI, based on animation, because it required hours and days of work to produce one single shot of video. But now the same technology, same capability is accessible to anyone with a single smartphone, now leading to unprecedented scale of manipulation that exists on cyberspace. Another challenge that has emerged is the crisis of trust. The proliferation of synthetic media has eroded the foundation of digital ecosystems, leading to a phenomenon known as the liar's dividend. This means that the AI-generated documents or AI-generated video files, audio files, document files are so easy to be produced and look so real to the actual evidences that individuals can easily dismiss even the genuine evidence as forged. So today, because we know that evidences can be like a real looking certificate, a real looking medical certificate, or a real looking education certificate can be so easily produced using artificial intelligence. Earlier, you had to use Photoshop and similar other tools, and still you could see the imperfections. Most of the times you could see certain imperfections and you could detect them. But today it has become nearly impossible to detect those imperfections with the naked eye. Therefore, it has become easy to disregard genuine evidences also in genuine cases. It is very easy for any person to say that this is AI generated, and then you have to do the entire investigation to find out whether the evidence is genuine or not for the completely genuine documents. Thirdly, this has now become, as I have said, a maturing threat vector. Now the deepfakes are no more targeted, no more focused on harmless parodies, but these are used for targeted, highly sophisticated attacks, including large-scale financial frauds, political and election manipulations, and personal defamation and personal violation of bodily integrity. Therefore, in this scenario, I emphasize why these regulations that have come up, the 2026 amendments to the 2021 regulations have been so critical and mark a critical shift towards the regulation. Now we are moving towards a reactive methodology, which was earlier based on if some content is found, we take it down, to a proactive framework where we focus on oversight, accountability, governance, and traceability of such synthetically generated content. Now, let us see directly what constitutes SGI. So SGI, that we understand as synthetically generated information. So this synthetically generated information has been defined under the new amendments that have been made in 2026. Those who are unaware, we are talking about the amendments in 2026, February 2026, that have been made into the 2021 regulations, which were intermediary IT intermediary guidelines in digital media ethics code of 2021. So these regulations were passed for giving certain obligations and mandates for the intermediaries like Facebook, Instagram, etc. And these amendments, 2026 amendments, which primarily focus on synthetically generated information and reducing the timelines, have been made into those intermediary guidelines, which are passed further under the IT Act 2000. So what is SGI? Now, to see SGI, we have to look at the definition of the SGI in clause WA of the Rule 2 of these amendments. So, synthetically generated information has been defined as any information which means audio, visual, or audio-visual information which is artificially or algorithmically generated, created, generated, or modified, or altered using a computer resource in a manner that such information appears to be real, authentic, or true, and depicts or portrays any individual or event in a manner that is likely to be perceived as indistinguishable from a natural person or a real world. So this is the definition, and it would be very pertinent if we break it down, the definition, and understand what exactly, which kind of information, which kind of content exactly has been included under the definition, and if anything has been left out. So firstly, we can see the three types of media that has been designated as synthetically generated information. Audio SGI, we talked about audio clone voices. So example, there were incidents of Ajit Singh's voice cloned for fake song scams. So this would constitute as audio SGI. If you receive a call from some person which you believe is your relative, but the relative is not actually talking to you, some AI application is talking to you by cloning the voice, then it is an audio SGI. Visual SGI means basically the morphed images or the AI generated images which look like the real images or the images of a real person or a real event. And lastly, it is the audio-visual SGI. Audio-visual SGI basically are the videos. Example, Sachin Tendulkar there was a deepfake video circulated of the star cricketer Sachin Tendulkar, where he was shown as promoting certain betting apps. But it was a completely deepfake generated video and he had no involvement. So these are the three kinds of content that have been included under the definition of SGI. Now, it would be fruitful if we see the different aspects of these definitions. So we have discussed the nature of this content, but I want to point it out very clearly that the nature of the content mentioned is audio-visual or audio-visual information, but pure textual content. That means text-based content. If you have used some GPT or Gemini or any other AI generative software to produce some text-based content, then purely text-based content is excluded from this definition. The definition does not mention text-based content, as well as there are certain clarifications released by MIT in a form of frequently asked questions. There is a PDF document. So that has further clarified that text-based content is not the subject of the definition of SGI. So if we generate something using SGI, generative AI and we generate a document, generate some newspaper report, which is false report, it still would be covered under the existing regulations or the existing rules under the intermediary guidelines related to removal of unlawful information, if that information is unlawful under any existing law, but it would not be treated as SGI. So for an SGI, there has to be visual, audio, or audio-visual information. Second important thing is the mode of creation. Now, the mode of creation, in regards mode of creation, this definition is technologically neutral. So law uses a broad language that is artificially or algorithmically created, generated, or modified or altered. It does not use the word AI. That means artificially created or algorithmically created. Algorithmically created would include artificial intelligence, but it could also be created some content, some morphed content, some unreal content, which looks like real, which looks like a real person. It is not the first time after the coming of generative AI we are creating such content. It was also created earlier also using traditional softwares like the Photoshop or certain video editing tools. But it used to take hours and days to create a video clip at least, or it would take hours to create a realistic looking image. So that is still included because artificially created content is included in the definition. That is included as the synthetically generated information. Synthetically generated information means anything that is not created, that not real information. It is created using some computer resource. That may be AI or that may not be AI. Secondly, it may be algorithmically created also. So algorithmically created, that is where the deepfakes come into picture and the generative AI comes into picture. And today, most of the synthetically generated information is AI generated information. So because it has become so easy to create such content using AI that it has become almost redundant to revert back to the existing traditional modes of creating content that look realistic. So even today, if a political group uses the Photoshop software to stitch a politician's head into someone else's body, and it is highly realistic, it will still be classified as SGI. Thirdly, and fourthly, there are two very important tests. So we discussed that there has to be some creation of audio-visual information, and secondly, that the mode of creation does not matter, provided it is computer-based creation. Thirdly, it is very important that the appearance should be real, authentic, or true. So the threshold content must pass the threshold of believability. It should appear to be real, authentic, or true. That means if you use AI to create cartoons or even cartoons of persons, say some CGI monsters or low quality lip syncing, that clearly indicates that it is a fake and it is not similar to any real person. Because you can, if you look at a cartoon of a person, we can clearly distinguish it that this is not a real person. Basically, you are not trying to deceive the audiences, the users. So in that case, it will not be treated as a synthetically generated information as per these definitions. It has to be real, authentic, or true, and it should be perceivably. So I will go to the exact part of the definition itself. You can see at the bottom. It should likely to be perceived as indistinguishable from a natural person or a real world. So it should likely to be perceived as indistinguishable from a natural or real person or a real world event. So that is the most important. What is the depiction of that? If it is being perceived or if it is likely that it will be perceived by the audience or the users as something that is indistinguishable from a natural person, in that case, it will be treated as SG. So this is the most important test. The content, audio-visual content that is created should be indistinguishable from a natural person or indistinguishable from a real world. So if something is being depicted, say, I am depicted as standing upon a speech and standing upon a stage and giving some speech about a political party or a political leader. And it appears like it is really a real world event. It is not it is very difficult to distinguish whether it is a real event or not. It is a SGI. So this is the most important test. Now one question arises here. So is the deep fake of a completely fictional person also covered under SGI? That means the technology has not been used to imitate or show any real person, but are giving you the scenario like a deep fake video has been being circulated online, where a news anchor is seen spreading financial information or some political information that is misinformation, and that is a AI generated news anchor. So AI generated news anchor is spreading some information and it is being circulated. That video is like, it say they are spreading some information about a particular religious community, now which has possibilities of leading to unrest in the society. And this is not a real. So whether it be treated, whether it will be covered under the definitions of SGI. So because the word used is indistinguishable from a natural person or the real world event, now further clarifications in the definitions are not. Now I would want to go into the depth of this discussion and a certain ambiguity that arises. But doing the interpretation, if we use a very hyper technical interpretation, it may be said that any individual would mean only an existing person. But taking in the context of the intention of the legislature, that is prevention of deception through the use of deepfakes or SGI, it clearly appears that the phrase indistinguishable from a natural person means any synthetic content that looks real and is indistinguishable from a natural person, whether that natural, it looks like the person is a natural real person, irrespective of the fact that we are replicating a real person or a fictional person. So even if a fictional person reads a news reading, does a news reading, and it appears clearly real that some news anchor is reading certain news information which is of a viral nature, which is offensive to a particular community, or which spreads some misinformation. The intention and the drafting of the definition, through the interpreting the intention and the drafting of the definition, we can make it reasonably sufficiently clear that the intention is to cover such cases also, irrespective of the fact whether a real person is presented or not. Because also there are certain reasons why I'm saying so, because it uses indistinguishable from a natural person, not the person, or does not further mention about the person who is being replicated, as is mentioned in certain future provisions, which relate to the dignity of the person whose deepfake is made. So in that case, the intention appears very clear that we are referring to a particular person. So drafting is like that in due diligence part. But here the drafting is not like that. Here there is a general draft. So without going into the depth of the entire interpretation scenario, I want to conclude that this definition makes it clear that natural persons, irrespective of whether they being fictional or imitating a real person, they are covered by the definition. And any event that appears to be true and real is covered by the definition. Now, most importantly, there are certain good faith exemptions of this definition. So we will deal with the definitions also, because it is very important to understand first what is SGI and what is the exemptions of SGI. Because when I will go through the exemptions, we will see that it will cover our daily scenario, our daily lives, because in our daily lives, we have started interacting with AI systems, and we are dealing with images, videos, and we are using artificial intelligence system for some kind of manipulations in those images. So I'm taking an example. I go to say a tourist destination somewhere in the Himalayas, and I want to take a good photograph of me. And I want to ensure, like we all used to do, that when our photo is being taken, there is no person in the background. But say it is a peak season of May and June, and it is very difficult to have a scenario where you can get where you can find a moment where there is no person in your background. So anyways, you have to take your photo with some persons there present in the background, but you don't want to post it like. So what you did, now we know the major operating systems today, particularly the smartphone makers like Samsung, the first one to come up with the extensive kind of AI-based editing and AI technology in their smartphones. And then Apple is also following by having a contract with Gemini, of course. So now they allow you to remove certain elements of the photo. So you have removed certain elements of the photograph. You have selected each person in the background and you have removed. And today's AI systems are capable of doing that so smoothly that they will remove all the persons and they will recreate the entire background to make it appear like you are the only person standing there in a particular scenic scenario or scenic scenery. So you have basically what you have done, you have edited an existing image using artificial intelligence. This is one kind of editing. Second kind of editing, I would give you the example. I just took a photo of myself, irrespective of the persons present in the background. I am not so particular about removing persons from the background. I am just keen on sharing that I went to this place and a beautiful place that was. But I realized that the one photo that I took, I got a little blurred in that. So I used, now the same could have been done through high, very good quality image editing softwares, but I am not trained in that. I used artificial intelligence. I asked Gemini or the Chat GPT to enhance this image. Because this image has got a little blurred, I asked it to correct this image. And they corrected this image, perhaps upscaled that image, or made some color corrections. Like you will see sometimes there is AI based auto correction mechanism. So they will change the colors, they will change the contrast, the color, the brightness, and make it visually appealing. I did that. Now, whether the AI tool has been used, now whether this will be called as synthetically generated information. So for that part, we have, if the exemptions do not exist, every such thing, because the word also, the definition also mentions alters, the word alters. So every such act would be covered under the creation of SGI. But here comes the exemptions for the protection. So first exemption is routine or good faith enhancement or editing. So if the routine enhancements or editing have been made, or good faith enhancements or editing have been made, like basic color correction, basic formatting, noise reduction in the images. So compression or transcription, that does not materially alter the content, the substance, or misrepresent the substance, context, or the meaning of that particular content, then in that case, it is exempted and it will not be covered under the definition of SGI. So we can take photographs, we can edit them using artificial intelligence, and it is not an SGI. However, the first scenario that I mentioned, where I removed people from that picture, now, do you think that it would fit under the scenario that does not materially alter the information or misrepresent the substance, context, or meaning? So this would be a very thin line. Say removal of a very small part of a tree or leaf may not be covered, may be covered under the routine good faith enhancements. But if you remove entire people from the picture, or certain parts of the certain monuments from the picture, then it will not be covered under these exceptions, because it does materially alter the information, or it may materially alter, or it may misrepresent the substance, context, or meaning. In that case, it is not covered by good faith exemption. So it will depend to what extent manipulations have been made in an existing content. Second exemption is for document. So today you can see my slides. The content has been developed by me, but I have used the help of Canva to design certain aspects of my slide to input certain graphical elements into the slide. So now that for that I have used the use of AI tools to develop this. Similarly, every day in our teaching and educational resources, we are relying upon AI softwares to design our content or sometimes to even create our content. So whether that would be treated as content that would be under the definition of SGI, so there is a clear exemption that generating of PDF presentations which may have graphic visual elements or educational or training materials is exempted, provided, most importantly, provided that no false document is so created. So if we have created some document, PDF document, so it is not covered under the definition of SGI. Or if we have created training materials, slides, images, these are not covered under the definition of SGI. But creation of documents, and it results in creation of some false documents. Like I am creating a PDF file and it results in creation of a fake medical certificate or fake education certificate, then it would be covered under the definition of SGI. So basically, it is covered under the definition of SGI, but in certain situations, some exemptions have been given, like in the case of using particularly the slide contents. So there would be exemptions and it will not be treated as SGI under the definitions. The further exception, the last exemption that has been provided exactly as exemption under the proviso clause of definition, clause WA, is accessibility tools. So use of computer resources solely for the purpose of improving the accessibility, the quality, the translation, description, searchability, or discovery of the information is not SGI. For example, like improving the quality. I have given you the example. The image is blurred, the video is blurred. There is some background noise in an audio file, and we use artificial intelligence to remove that background noise to make the contents of the sound recording more clear and more audible. We improve the video. We have come across a very low resolution video, and we have used AI to upscale the resolution. Then that is not covered under the SGI and it is covered under the exemption. It could also cover cases like translation. So we have one speech given by a particular person in a particular language, in Hindi say, and we have used AI to translate that speech in English. It is also covered under the exemption, provided nothing new. The computer resource is solely used for that. If something new has been added, a new voice or a new word has been added that has not been said by that person, then it would be not be protected under the exemptions. And lastly, one exemption I have written, which is not expressly written as an exemption, the obvious fake exemption, because it is covered by the definition. So something that is generated using AI generative tools, but it is obvious that it is exaggerated or it has a comedic effect, that there again would be a borderline here. But still, if it is so clear that this is an exaggerated content and not a real content, like I'm showing a political leader flying in the sky, like Red Bull gives you wings. So similarly, we have seen the ad of Red Bull gives you wings, the person starts flying. So if we depict that scenario with any person, a natural person also, and it is very obvious that it does not create any likelihood of being indistinguishable from the real scenario. It is very clear the context in which it is being circulated. It is very clear that this is obviously a manipulated content, and it is not attempting at any deception at all. Then in that case, such obvious kind of contents would also be exempted, not because they are provided under proviso clause, but because they are not included in the definition itself. They are not likely to be perceived as indistinguishable, and they do not look like real, completely real. Or even if they look like real, but they are completely distinguishable from the real person or the real. So these are the certain good faith exemptions. Now, I have mentioned about accessibility. So the test of accessibility, as I have already stated, that the moment the tool is used to create something new and is not mere translation or enhancement of the content, then it will become something that is a SGI generated content. If we have an image, we can use we can use AI to run OCR on that image. And the contents of the image, say there is text in the image, which is not directly readable. That is readable to the naked eye, but not read by the system. You all know if we use OCR on them, in that case, the image will be covered under accessibility exemption because it is increasing the searchability of that. But if it has resulted in something new, some text that is not there and is now visible, then it will be not be covered under the exemption and it will be treated as the SGI content. Now, we have taken a significant time to discuss this definition, but it was very important to understand what has been included as SGI and what has been exempted from SGI. Now, there is a extensive level of discussion that is needed to discuss the regulation of SGI content, particularly because we need, while we discuss SGI content, the regulation of SGI content, we also need to discuss certain parts of intermediary guidelines itself, because these are amendments into the existing intermediary guidelines. So we cannot understand the amendments in isolation if we do not understand the underlying provisions. So for that, I have tried to include all the possible rules that are necessary, that are most relevant for understanding the regulation of SGI under the intermediary guidelines. So starting directly with it, dealing with the regulatory mandates and the due diligence requirements for intermediaries. Now, first kind of mandates that we will discuss is a requirement of informing the users about certain aspects. So regulation 3, for most of the time of this session, we will be dealing with regulation 3. As in Act, there are sections 1, 2, 3. Because this is regulation, there is regulation 3, regulation number 3, which comes after the definition regulation, regulation number 2. So in regulation number 3, sub rule 1, there is some requirement of information to the users. So firstly, in regulation sub rule 1, clause B, a list of acts are provided that are deemed as unlawful, like circulation of content that is protected by intellectual property rights, or circulation of content that is obscene, pornographic, or pedophile. So these under regulation 1B, clause B of sub rule 1 of rule 3, these are the intermediaries are bound to inform the users that you should not host or upload such content on the platform of the intermediary. Now, with 2026 amendments, they added 2 specific subclauses to this regulation number 1, subclause CA and subclause CB. Subclause CA and CB directly deal with SGI content. So apart from those informing the users about what content is deemed as unlawful and which should not be uploaded, hosted, circulated over the intermediaries platform, now intermediaries are also obligated to inform the users they are obligated to inform about some additional explicit information apart from 3.1b and its consequences. So that firstly is under the subclause 1.1, that is, intermediary has to provide a clear information detailing the prohibition of generating unlawful synthetically generated information, and they have to inform that the contravention may lead to penalty, punishment under the relevant legal provisions. So this list is provided, the list of these things is provided in sub rule 3 of rule 3, clause A. Now sub rule 3 deals with due diligence requirements. We will come to that rule again, but here itself, because this rule, clause CA refers that whatever is mentioned in clause A of subrule 3, where due diligence requirements of intermediaries is there, you have to inform the different kinds of acts are mentioned, the different kind of information is mentioned, content is mentioned that is unlawful. So you have to inform under clause CA, intermediaries bound to inform its users about the unlawfulness of such content. I have mentioned those content here itself, that is generation of pornographic, obscene content or child sexual abuse material, which is known as CSAM, or material that is violative of someone's privacy. Secondly, creation, generation, modification, or alteration of any false document or false electronic records. So you cannot use SGI to do either of these. You cannot use SGI to create any false document or false electronic record. You cannot use SGI for any purposes related with preparation, development, or procurement of explosive material, arms, or ammunitions. And you cannot use SGI to falsely depict or portray a natural person or a real world event likely to deceive such person's identity, voice, conduct, action, or such event as having occurred. Now, if you look at the fourth part, falsely depicts or portrays a natural person or a real world event likely to deceive. It does not end here, because this is the definition of SGI itself, but it is talking about a particular kind of SGI, where such person's identity, voice, conduct, or such event is being deceived, or such event is likely is being portrayed as having occurred. Basically, what is happening here? Now, here you are depicting some real person and deceiving the identity of that. So therefore, I said in the definition in under WA that it appears that natural person there means any natural person, whether it be real or fictional. But because here in the fourth part, where unlawful SGI is mentioned, they specifically mention that if such SGI that portrays a natural person deceives any person's identity, voice, or conduct. So deceiving a person's identity, voice, or conduct would happen when such person is a real person. So if you are deceiving some real person's identity, voice, or conduct, or action, or a statement, then such kind of SGI would be treated as unlawful. And under CA, subclause CA, you have to, as an intermediary, you have to inform your users that such kind of content is prohibited. Now, under clause CB, so there is one more thing. Under clause CA, there is also a requirement to inform the users that for the acts mentioned previously, for the informations, unlawful information mentioned previously under the subclause 3, under the subrule 3 and clause A, which we right now discussed, you also have to inform the users that contravention of this, that if you upload, circulate, use the tools provided by intermediaries to create such kind of these 4 categories of SGI, then they also inform you that in such cases, it would result in immediate removal of such information. These things they have to inform their users. It could result in suspension or termination of the user account of the user. It could also result in identification of such user and disclosure of the identity of the uploader or the person who has created such SGI to the complainant or the relevant authority. And lastly, such kind of conduct by the user on the intermediary platform could also result, if it results in some kind of offense, then intermediary may also report such offense to the appropriate authority. So if you have used SGI to create some pornographic content that is prohibited by law, and users are also prohibited to do that by law, like users are prohibited to circulate pornographic content, and users are also prohibited to even seek content that is related to child sexual abuse material. And in POCSO, there is a mandatory reporting mechanism also. So when you are aware of some POCSO related offense happening, you are under obligation as a citizen to report it to the necessary authority. So if that information is covered under the existing law that requires mandatory reporting, then your intermediary can also report that to the appropriate authority. So under clause CA, this information has to be provided to the users. Understand that it is an intermediary. Regulations are focusing upon the intermediaries. So all these obligations have been cast upon the intermediaries, not users directly. So intermediaries have to do that. Intermediaries have to inform their users. Now, secondly, under clause CB, there is requirement of mandatory enforcement action also. So whatever content we have discussed, that intermediary has to inform the users that this is prohibited kind of SGI and that certain actions can be taken under the clause CA if such kind of SGI is circulated. Clause CB, which is also an addition, recent addition, it mandates enforcement. So it obligates the intermediary to take appropriate action if the content that is uploaded is of the nature that is mentioned in the previous clause. So therefore, it shows now that there is a shift regarding platform liability. Intermediaries who are providing generative AI tools cannot simply claim immunity as passive transmitters. If the platform supplies the infrastructure to create the synthetically generated information, it is also bound to inform the users of the legal boundaries of such use, and it is bound to penalize violations of these rules through the form of disabling access to that content or disabling the user account also. And if it is an offense, it may be required to be reported to the relevant government authorities also. Now, we are coming to the another kind of mandate that is related to the removal of. So, the removal of content works in two ways. Now, basically here I am covering the scheme of the intermediary guidelines itself related to removal of the content. Because we need to deal with to understand how even the SGI content can be removed. So it works in two different ways. A removal can be ordered by the court or an appropriate government agency under the sub-rule 1, clause D of rule 3. This clause has been existing since 2021 regulations, and it has been there even before, since 2011 regulations itself. But certain amendments have been made. This clause requires the removal of the unlawful content, which could include SGI content also, on government order or on intimation by the government authority within 3 hours. It is to be noted within 3 hours. The earlier deadline before the amendments was 36 hours. So another aspect of 2026 amendments is reduction of timelines and drastic reduction of timelines. Secondly, removal works under a private grievance redressal framework, under which, based on the complaints by the users, the intermediary can also address that complaint, and if necessary, it can remove certain content. So for that, there is sub-rule 2 under rule 3 that deals with grievance redressal mechanism. So basically, we will discuss those rules. There are 3 kinds of timelines under sub-rule 2. We will discuss those. Coming to the first kind of removal, the mandatory action, where you have to, intermediary under clause D of sub-rule 1 of rule 3 is required to remove unlawful information from the intermediary's platform upon receiving actual knowledge. I believe many of you here now would be aware of what actual knowledge means, as it was interpreted in Shreya Singhal versus Union of India in 2015. It was a time before the 2021 guidelines, and actual knowledge. Earlier, there in 2011 regulations, there was no explanation of what constitutes actual knowledge. In 2015, Shreya Singhal versus Union of India, apart from doing away with section 66A, they also provided that actual knowledge means a court order or a government intimation. The same view that was given by the court was adopted in 2021 guidelines. So now they explain actual knowledge as a court order or intimation from the government agency. However, there are further amendments made in this particular sub-rule in 2025 and 2026. Now it means actual knowledge means a court order or recent intimation from an authorized government agency. And this authorized government agency is not a person below the rank of joint secretary in the government department, or if it is from the police, then not a person below the position of DIG office. Because there were why such protections have been issued? Because it could have, if any person, say a simple police officer, say a station in charge is able to give orders to take down certain content, it could lead to chilling effect on freedom of speech and expression. Because then intermediary would have to remove certain information, even though it may not be covered under the, it may not exactly be an unlawful content. Satirical content, or content that is clearly a hyperbole, a fair commentary on the existing process, or is just a satire. It could also be taken down under 3(1)(d). So therefore, now they have provided a very clear protection that it has a particular kind of government officer is needed, government agency is needed, who can give a reasoned intimation, a reasoned order why you are asking the removal. And now this actually happens through a government Sahyog portal. So government has developed its indigenous Sahyog portal where different government agencies can log in and ask for taking down content, and that will be routed directly to the intermediaries. Most of the major intermediaries have been onboarded on this Sahyog portal. They will get the intimation directly. Some intermediaries like X have not boarded and they have challenged the constitutionality of the Sahyog portal. The case is still pending in the Bombay High Court, I guess. But this is how this mechanism exists. So you need, for actual knowledge of unlawful information being hosted, you have to provide a court order or a intimation from the government agency. Now, which kind of information can be removed under this clause? So there is a wide ambit of content that can be removed. The clause, D clause itself mentions that in interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, decency, morality, public order, most importantly, it's a wide term, in relation to contempt of court, defamation, incitement to an offense related to the above, and any other information which is prohibited under any law for the time being. So this is a broad clause, any information that is prohibited. So it will cover the copyright laws and many different kind of laws where the circulation of the information is prohibited. Like you cannot circulate something that is a subject matter of someone else's copyright or patent. You cannot share that over the cyberspace. Now, this is the mechanism for mandatory action. Now, as I mentioned, the timeline for removal after you receive the government intimation on the court order is 3 hours. Earlier, it was 36 hours. So we can see a critical change regarding the which affects the intermediaries. Now, within 3 hours of receiving that order, they have to remove the content because the law acknowledges the extensive harms that could be resulted in the cyberspace, particularly with the coming of generative artificial intelligence. So though this section does not expressly deal with generative artificial intelligence, but any kind of generative AI-based information which fits under any of these subpoints could be requested to be taken down by the court or the relevant designated authorities. And if the intermediary does not take it down, they will lose the safe harbor protections provided to them under Section 79 of the IT Act. We will not go into the depth of the safe harbor protections, but they will lose the safe harbor protections. That means now they will not be treated as intermediary. They can be treated as publisher of that information and can be subjected to the relevant prosecution under the relevant law, as if they themselves publish that content and it is not a third party content. Second kind of takedown mechanism is under the grievance redressal mechanism, which exists under subclause 2 of the Rule 3. Now, just taking a brief time to explain the grievance redressal mechanism. Grievance redressal mechanism existed even before the 2026 amendments. It requires the intermediaries to provide a grievance officer, the contact details of the grievance officer, and a method for the users to lodge complaints with that particular intermediary, including complaints related to removal of particular kind of information. So what has to be done? What is the process? Once the complaint is filed through the grievance redressal mechanism, the grievance officer is obligated to acknowledge the complaint within 24 hours and the intermediary is required to resolve the complaint within 7 days. Earlier it was 15 days, but now the requirement is 7 days. So they have reduced the timeline of 15 days resolution to 7 days resolution now. Now, there is also a provision of expedited disposal timeline. So, any grievance that has to be resolved within 7 days. However, the sub clause also provides for specific kinds of grievance under the proviso that have to be resolved within the period of 36 hours. So this is an expedited disposal time. For certain kinds of complaints, those complaints have to be resolved within a period of 36 hours only rather than 7 days. Earlier, this period was 72 hours for expedited disposal. Now this is 36 hours. So what kinds of information is covered here? Again, the information, as I mentioned in the beginning, clause B of sub-rule 1 provides certain content, certain information that intermediary must inform its users that it cannot be circulated on the platform. So if complaint relates to the removal of such information, it has to be resolved not within 7 days, but within 36 hours only. I have taken the Bare Act itself to show you this clause B of sub-rule 1. So there are 11 points under this clause B. It is very difficult to cover it in the limited time, but still you can see, clause the point 2, obscene, pornographic, pedophilic content that is invasive of someone's bodily privacy, content that could result in a racially or ethnically objectionable content that could result in money laundering, gambling, or online game that causes harm or promotes enmity between different religious or caste groups. Content that is harmful to the child. Fifth, you can read content that deceives or misleads the addressee about the origin of the message. So you have used some SGI to make a content that misleads about the origin of the message. It appears that it is being circulated by someone else while it is being circulated by someone other person. Now, content that impersonates any other person, that threatens the unity, integrity, defense, security, sovereignty, and basically all the things that are mentioned in exceptions to Article 19(2) of the Constitution. A content that is a computer virus or any other malicious computer code that can destroy or limit the functionality of the computer resource. An online game that is not verified as a permissible online game, or violates any other law for the time being. But let me tell you, this expedited disposal timeline is applicable for all these except point 1, 4, and 11. So point 1 is if the information belongs to another person and to which the user does not have any right. Expedited disposal timeline is not applicable. That means for such content, the intermediary can handle it within 7 days rather than 36 days. Fourth is infringes any intellectual property rights. So again, intermediary can take a 7 days time to decide such kind of complaint. And lastly, any complaint that violates any law for the time. So other than these, if any law is being violated, intermediary can take 7 days timeline, and 36 days timeline is not mandatory. Now, another expedited timeline is there, which I have called a special timeline, which mentions the 2-hour removal mandate for very particular kind of information. That is mentioned in clause B of sub-rule 2 of rule 3. We were discussing clause A, now this is clause B. It mentions specifically that if the information exposes private parts, portrays individual in a state of nudity, or depicts sexual acts, then in that case, upon the complaint by the person who is affected, the intermediary is bound to address that complaint within a period of strictly 2 hours. So from 36 hours, from 7 days, expedited timeline comes to 36 hours. And for this special kind of content, it is drastically reduced to 2 hours only. So why is it reduced to 2 hours? Because we understand that the circulation of someone's body, private parts over cyberspace is a very sensitive matter, and it could, if it becomes, it could become viral within moments. And if it becomes viral within moment, it would cast a lifelong impact upon the dignity of that individual. Therefore, realizing that exigency, they have reduced the timeline here to strict 2 hours. You have to decide the complaint within the 2 hour window in this particular case. Now, I have taken the liberty to also show you, because I believe we are having this discussion, and we as consumers of such services, the services provided by intermediaries, should not just theoretically understand this grievance redressal process, but we also should be able to locate this grievance redressal page. I have told you that intermediaries are bound to provide grievance redressal officer and their contact number and a method of lodging complaints under the previous rules. So I have provided you certain screenshots of the different intermediaries. Like the first one, you can see Meta. So in Hindi, you can see Bhartiya Shikayat Nivaran Adhikari se shikayat ke liye you have to choose certain aspects, whether it is Facebook, Instagram, or Threads. So basically, it is the grievance redressal officer. And then you can see Meta's Instagram itself. I have taken this screenshot from the support page of the Instagram, where you can see they have clearly mentioned below is the contact information for Instagram's grievance officer, and grievance redressal process was also explained there. So you can see the name and the contact. Further, you can see a Snapchat. I have provided how you can locate the grievance redressal person in the Snapchat. They have provided the entire details of the grievance officer and their contact details. To the right, you can see the grievance officer details in case of YouTube. So these were some of the major intermediaries of India operating in India, and we can see each of these have provided a grievance redressal officer and a mechanism to lodge complaints. So even if you just simply search grievance redressal officer, in most of the cases, you will get across the page of the intermediary that mentions about the grievance redressal officer. You can contact them directly, or sometimes pages have provided a specific mechanism, a form where you can lodge a complaint to the grievance redressal officer, and they will have to deal with those complaints as per the timelines that we discussed. So this is how we can ensure that if something related to us, something offensive is actually uploaded, we have a mechanism, a binding mechanism under the intermediary guidelines to raise our complaints, and you can see that they have been put under obligation to address your complaint within a limited time. So they cannot take the defense of infrastructural issues or the extensive number of users they have. If they have the users, they have to provide this mechanism. They have to ensure the takedown mechanism based on your complaint. Now, moving further to the due diligence requirements under the new guidelines. So we have discussed sub-rule 2, we have discussed sub-rule 1, which provides certain information mandates to the users. Sub-rule 2, which provided for some takedown mechanisms, and clause D of sub-rule 1 also provided for takedown mechanism in case of government order or government intimation or court order. Now we are going to deal with the due diligence requirements for intermediaries offering SGI generation services. So this sub-rule 3 is a new addition by the way of 2026 amendments itself. Sub-rule 3 mentions two kinds of due diligence requirements for intermediaries like Facebook, Instagram, who are also providing services related to creation of synthetically generated information. So today you can see even the YouTube, Instagram, they are providing their own tools for creating SGI information. So in that case, they have to ensure due diligence, which are mentioned in clause A of subrule 3. So directly coming to those requirements, seeing the paucity of time. First requirement is structural safety guardrails. Now let us discuss what this is. Point 1 of clause A of subrule 3 of rule A prohibits the use of an intermediary's computer resource to generate SGI that commits certain specific harms. This is what we referred previously also. The clause A of subrule 3. So this is what we referred previously, the creation using, if you use the intermediaries software tools for creation of some content that is pornographic, obscene, pedophilic, vulgar, indecent, related to child sexual abuse material, or it is being used for creation of any false document or false electronic record. It is related in used in relation to explosive material, arms or ammunition, or it falsely depicts or portrays a natural person in a manner that is likely to deceive such person's identity. Basically, you are deceiving some real person's identity by using SGI, cloning their voice, and you are using intermediaries tools to do that. Then it is prohibited, and intermediaries must ensure certain guardrails to prevent the generation of SGI that results in this. Now, what are these guardrails? So these guardrails means every intermediary who is offering such kind of service to an option to create synthetically generated information must ensure that they have deployed some technical infrastructure, automated tools that prevent creation of such kind of content. So that users cannot use the SGIs, the intermediaries SGI generation software or SGI generation website to create any content that is any of the following. So you cannot, intermediaries have to make sure that their tool cannot be used for developing pornographic content. So today you can, if you input such kind of prompts, you will tell, you will see that in the SGI the generative AI tools will tell you that they cannot create such content because this is either obscene content or this comes in conflict with any. So basically it has to fit under any of these categories. Second requirement, mandatory traceability and provenance. So this is required under point 2 of clause A. So point 1 of clause A mentions those kind of SGI that is prohibited and that cannot be generated using SGI's intermediaries tools. Second, if the creation of such SGI is not prohibited by point 1, it does not fit in any of these 4 kind of informations, then it is allowed. But then there is further additional due diligence requirement that for allowed SGI, as the intermediary should ensure that the content has a permanent machine readable metadata. So what is a metadata? Metadata is a unique identifier attached with a file. You have created one image. That image will have some metadata which you will not see directly. But if you see the properties of the image or in certain softwares, you can see those details. So if it is a synthetically generated image or video, intermediary has to make sure that the metadata of that file expressly mentions that it was created using artificial intelligence. So it can go a long way in dealing with the menace of deepfakes in India and across the jurisdictions. If you are mandated to ensure that metadata exists and metadata of that file mentions that it is generated by artificial intelligence. Secondly, it should also have some visible indicator or watermark that is adequately perceivable, indicating that the information is synthetically generated. Now, in case of audio files, obviously you cannot have a visible indicator. So in the case of audio file, what you will have a prefixed audio disclosure. Say you have created an audio a song based on artificial intelligence. So that should, in the beginning, tell you that it is created using artificial intelligence too. So it will also, the visible indicator is again much more important because it can immediately tell the users that this video is AI generated. So this is not a real world event because visibly looking at that video or image, they can tell that this is AI generated. For metadata, you have to go through the particular softwares or see the properties of the file. And this metadata must also indicate the identity of the intermediary generating the SGI and the date and time of its generation. Now I present before you. For that, I would want you to use the chat box, or you can use open the mics also. So I present you before you one image of the professor teaching intermediary guidelines. So in our institution also, we specifically deal with cyber law. So I have presented you one image. Now I want you to tell me whether this is AI generated image or not. So you can use the chat box for that. I need at least certain comments before we can proceed further. So you can look at this image of a professor sitting in the classroom teaching something related to intermediary guidelines itself. Whether it is AI generated, rest of the participants, at least 3, 4 more answers based on your best guess. Okay, so I have received one answer that it is AI generated, and we are already exceeding time. Now, very good. So Gargi ji has commented that there is a Gemini logo, and that is why it is AI generated. This is what I wanted you to identify in this. Now, this looks like a real image. Many of us can still tell that this is AI generated image. And now look at this logo, Gemini logo. So those of us who have used Gemini, Google's Gemini AI to create images know that it puts a visible indicator. Here you can see at the bottom right, a visible indicator. So this is the visible indicator that we are talking about. This is the visible indicator that we discussed here, that there has to be a visible indicator or watermark. So this is the visible indicator. Now I want you to see another image. I have created we have given you the same scenario. Now can you tell me this is AI generated or not? We would need some fast answers because we are exceeding the time. So Kashish has said it is hard to say. Any other answer? So Gargi ji has once again commented that this is not AI. And Kashish ji is also saying that maybe it's real. So now let me tell you, this is also completely AI generated, but it is much more real compared to the previous image. Now it is almost completely impossible for the naked eye to identify because I have given particular kind of prompts to make it show that this picture is much more sophisticated than the previous picture, and particularly because Gargi ji said that there was the Gemini logo. But in this image, can you see any visible indicator that shows that this is AI generated image? Is there a visual mark? So no, there is no visual mark. We cannot see any visual mark. But still, let me tell you, there is a meta tag in this image. So again, to make you aware of how this works, I will take extra 2 minutes to show you how this works. In this image, which I tell you is also AI generated image, looks like a very real image. Even a water bottle and the Dell laptop being kept. So, though there is no visual indicator, there is meta tag in this image, which is being discussed in the intermediary guidelines to be mandatory. So let me show you the meta tag. Firstly, I will take the first image that you all saw. So what I have opened a website that is able to show you the meta tags. I'm not using a native application. You can use a native application also, and you can use the website also. One good website is Origin Verify. So now when I uploaded this image into this website, it will give me all the metadata related to that website. And on the right, you can see it shows you the name of the publisher, Google Media Processing Services, media signed by Google LLC. So it gives us the clarity that this image is based on reading its meta tag. It tells us that this is AI generated image. Secondly, I have taken the liberty of uploading it pre-hand before the session to save time. The second image you saw, again, I input that image in this website where there is no visible indicator, but still you can see the publisher's name has been identified. Open AI Media Service, because this image was generated using ChatGPT. So meta tag exists. We were not able to see that, but when in the website, you can see the meta tags. So this is what we are talking has become mandatory under the intermediary guidelines for the intermediaries. Now, I would take another just 5 minutes and will wind up the session to discuss an additional requirement for significant social media intermediaries. So we have discussed all the requirements related to SGI, but there are a category of intermediaries. Even the intermediaries are categorized into different kinds of intermediaries, like online gaming intermediary, social media intermediary, and significant social media intermediary. So for significant social media intermediary, there is additional due diligence obligation. So what is the additional due diligence obligation? Before that, let us see what is the significant social media intermediary. So significant social media intermediary has been defined under the definition, under the rules itself. It is that intermediary. So basically, social media intermediary is also defined as the intermediary which allows the users to share their interact with other users on their intermediary platform. And in that, a subheading is there, subclassification is there, a significant social media intermediary. So any social media intermediary whose now how does the definition define that whose registered user base exceeds a specific threshold as notified by the central government, and central government has notified the threshold of 50 lakhs. So if any social media intermediary has users more than 50 lakhs in India, registered users more than 50 lakhs in India, then that social media intermediary will be treated as the significant social media intermediary. So today we can see that most of the intermediaries, as you can see on the screen, Facebook, Instagram, YouTube, X, all these have more than 50 lakh users. So they are significant social media intermediaries, and significant social media intermediaries are under additional due diligence obligations. Now, why this classification has been made? So we can see the purpose of the intention of the regulations here, that if you circulate a deep fake content on a platform with just 500 users, it does not pose the level of systemic risk which is posed if the same content is shared over a social media platform that has 50 lakh users or crores of users. It has the more propensity of getting viral within limited time and reaching every corner of it and causing significant harm in a minuscule amount of time. So therefore, this classification has been made. And for such intermediaries, they are put under special due diligence requirements, that is mandatory user declaration and technical verification firstly. So these are covered under Rule 4. Rule 4, new subrule 1A has been inserted. So before any content is uploaded or published, the significant social media intermediaries must require the users to declare that the information is synthetically generated. If it is synthetically generated, they must require users to declare the information to be synthetically generated. And such kind of SSMI must also deploy some kind of tools that can verify the accuracy of this declaration. That means you ask the users to declare if the content is SGI generated. And you should have a mechanism, a technological mechanism to detect also whether this declaration is true or not. That means you should be able to detect whether the content that is being uploaded is AI generated or not. So today, these rules have just come into force, and today you will see many times when you upload some content, the intermediary detects it as online AI generated content. And sometimes it requires certain additional obligations, or sometimes if it is seen that it is a violative kind of AI, it may not even allow you to upload that. So because they have deployed their own tools to detect such content based on the metadata of the file that we discussed, or it could be based on some kind of signature, visible signature that is present there. Secondly, they have to ensure a proactive labeling. So if they allow users to upload SGI content, then they should ensure that a prominent label is also annexed to that content.
Sorry for inconvenience and sorry for interrupting you.
I understand
But
that I'm exceeding the time, right?
yes, sir, we are short on time and we have question on answer session as well. So if you can
So
please bring it to
I
a
will just take
conclusion.
2 minutes. This is my last substantive slide.
Yes, sir. Thank you so much. Thank you so much, sir.
So another requirement is proactive labeling. Whenever users upload any content, you have to label that content that it is synthetically generated. So if I have uploaded synthetically generated content, Facebook must label it as it is AI generated content so that the other users can know. And there has to be a dedicated reporting mechanism. That means as AI generated content. That means if I am a user and I come across a content that was not labeled as synthetically generated content, but I know for a fact that this is not real content, so I should be have some provision to inform the intermediary that this is a AI generated content. And in that case, intermediary may take the necessary action, or it may label that content as AI generated content. So this finishes the substantive part of the slides. I have tried to cover because these amendments have been relying upon the intermediary guidelines that have been existing since 2021. So I tried to somehow give you the entire understanding of all the changes that have been made along with the existing intermediary regulations. Now, we can go to the question sessions. Before that, I put certain questions before you. These questions which you may ponder upon, which you may further research upon and discuss. And if any of these questions are not already asked, so I will just discuss two of these questions that I have put before you and provide the answers myself. So we are open for the question answer session.
Thank you so much, sir, for this incredibly detailed and insightful session. Now, the floor is open for questions. We are only going to take few questions because we are already running short of time. You may please drop your questions in the chat box. Sir will be taking up the questions one by one. Thank you so much. Also, if any one of you wants to speak directly, you may please raise your hand, then we will bring you in one by one as well. Thank you.
We are getting questions about participation certificates. So I believe there would be, but let us deal with the substantive issue that we discussed today. Or some of you, if you want, you can ask any of the questions that are before you in the slide, or you can take a screenshot of them. Because I don't have the sufficient time to discuss each of these questions, but if you ask any of these questions, we can discuss them. I believe I have already exceeded the time on the Sunday, and because this has been, I have put too much into the session that our participants are not able to frame exact questions that they may want to ask, or it may have been too much for the participants. I realized that was too much information in a limited period of time. So we will wait another 2 minutes. By the time I would answer certain questions that I have put before you myself. Okay, there is one question from Kashish ji. If a regular user accidentally forwards an AI generated fake video or piece of news, can legal action be taken against that user under the new IT rules 2026? So this will clarify, this will also answer some of the my questions also that I have put before you. A very important question. So again, I want to emphasize, and your question is also going to answer question 1, 2, and 6 that I have put here. Whether the user who forwards AI generated fake videos or that may be treated as unlawful would be liable under the new IT rules 2026. No, they will not be liable. Why? Because these IT rules, now the nature of these rules that have been passed, though a comprehensive amendment has been passed thoughtfully, but the nature still remains that it is an amendment in the intermediary guidelines. Intermediary guidelines are again passed under the IT Act 2000, and the purpose of these intermediary guidelines are that if the intermediaries are doing whatever is mentioned in the guidelines, they will retain their safe harbor protection under Section 79. That means if they do these due diligence requirements, they can claim themselves as intermediaries and not the actual publishers of content if some unlawful content actually finds placed on their platform. But it does not put any liability upon user. You have seen that intermediaries are bound to inform the users that you can be, your user account can be disabled, you can be prosecuted, but directly no liability is cast upon the user. It is upon the intermediary to disable that user's account or to report that account to the relevant authorities. User facing, that is why I say the first question, whether deepfake creation is completely regulated in India now, and whether there is a complete user facing ban on creating unlawful SGI. No, there is nothing user facing. This law does not deal with users. However, again, if you as a user are circulating some content that is unlawful content, then you can be covered under the respective existing legislations. Like if it is a impersonating content, then you can be covered under Section 66C or Section 66D of the Act. You can be covered under Section 67 for pornographic content, or you can be covered under Section 67B for child pornographic content. You can be covered under BNS for content related to promoting enmity between different religious groups, and you can be booked under those respective laws, but not for the fact of circulating, not for the fact of creating SGI or circulating SGI ipso facto, unless it is also an offense under an existing law. So therefore, I say whether deepfake creation is completely regulated in India now. India now again. Uh, just give me 1 minute, a brief one. So sorry, there was someone on the door. So what I was saying that the creation, even the regarding user facing, we can create as a user can create SGI using their own tools to create SGI, and these regulations will be applicable to intermediaries only. Now, another most important question that arises, which I also want you to do the research upon, interpret the law accordingly, that whether notable AI generative AI services like ChatGPT, Cloud and Germany are covered under these regulations, because these are intermediary regulations. These cover the intermediaries. So Facebook, Instagram, if they are offering tools related to SGI, they are covered. Under significant social media intermediaries are covered, even for the fact that if I upload some SGI information, they are mandated to label it and check it, whether it is SGI or not. But at the creation level, their tools are covered. if they offer tools for creation, we have seen it is covered. But what if Chat GPT, Cloud and Gemini, which are regularly being used to generate AI, generate deepfakes, images or videos? The question arises whether they are intermediary. Going by the strict definition of intermediary under clause W of section 2 of the IT Act, I would say that these are not covered as intermediaries, because intermediary is a person who uh, receives a resource from the user and provides some kind of service regarding that resource. Like I can upload my content online and they will circulate it to the other users. But if they are themselves providing us services of creation on their own end, then they are not intermediary. वो intermediary नहीं है. They are providing services to us. So then they will not be covered under the regulations. Then a large, a huge, the major part of the deep fake creation channel is not being covered under these regulations. Even though if such regulations enter the social media platforms, they will be covered because social media intermediaries will come into picture. But merely at the level of creation, it is not being covered. So here lies the loophole. Now, some scholars have actually said that the wordings of sub rule 3 of rule 3 may actually cover such kind of intermediaries also. The clarification is not. So we have to see whether they can be extended into the definition of intermediary. But what I suggest therefore is, and the answer to the last question, these amendments are not sufficient because they focus on intermediaries. But still, I have shown you that the images created from Gemini and Chat GPT both had meta tags. Why did they have meta tags when the law does not mandate them? Firstly, they are voluntarily doing so. And secondly, because there are laws like European Union Artificial Intelligence Act, which regulates artificial intelligence in general. And it puts the obligation upon the deployers of AI systems to ensure transparency obligations. They have to tell that if something is created using artificial intelligence. So therefore, meta tags exist. And visible indicators also exist to some extent. But again, whether this is the comprehensive amendment, this is for intermediary facing, it is comprehensive, but still much more needs to be done for regulating the AI, towards the AI governance landscape in India, and particularly in respect of deepfake crisis in India. Thank you.
Thank
So
you
that would
so
be all from my side.
Thank you so much, sir. And once again, on behalf of everyone who is present in this meeting right now, we extend our sincere gratitude to you for joining us today and sharing your knowledge and wisdom with us. And with that, we come to the end of this session. We hope today's conversation was as enriching and thought provoking for you as it was for us. Discussions like these remind us that why work matters and why staying informed is one of the most powerful things we can do. On behalf of Naksh Foundation and Project Cyber Shield, we extend our deepest thanks to Mr. Shikhar Gupta for a session that was insightful, practical, and genuinely inspiring. Before you all leave, please take a moment to complete the post assessment form by scanning the QR code on your screen. Certificates will be issued upon successful submission. So please submit the form at the earliest possible. Till then, stay vigilant, stay informed, and keep strengthening the shield against cyber threats. Thank you all. Once again, thank you so much, sir, for joining us today. It was nice having you here with us.
Thank you for
Thank you so
inviting
much.
me, ma'am, and thank you all the participants for being patiently here. And as we exceeded the 30 minutes also. So thank you, everyone.
Thank you, sir. Everyone, the post assessment QR code is visible on the screen. You may please scan it and fill the post assessment form. Thank you so much.